Welcome back. In our previous sessions, we've been talking about Article 2 of the Constitution, the executive branch, the presidency, and we're going to continue that conversation for the next couple of sessions. We started talking about numbers that at first you might not notice, but actually contain very interesting stories. The number 4, a presidency is a 4-year term, and at the founding, that was unprecedented. No governor had a 4-year term. Only New York had a 3-year term. But today, 48 of the governors, of the 50 governors, actually have 4-year terms because their governorships have begun to be modeled, have been, in fact, modeled on the American presidency in all sorts of ways. We talked about the number 0. 0 property qualifications in order to be president, unlike property qualifications that existed for most governorships, all the governorships really, at the time the Constitution was adopted. No governorships today. And when you think about the fact that the Constitution creates a strong presidency open to low-born persons, it's pretty remarkable when you remember that in England, the chief of the head of state is anything but low-born. He's a monarch, to the throne born. But in America, folks born in very modest circumstances have become president because of that invisible number, what's not there, property qualification, 0. Andrew Jackson, low-born. Ulysses S. Grant, Harry Truman, Ronald Reagan, Gerald Ford, Bill Clinton, Barack Obama. Now, some of these folks had acquired some modest fortunes by the time they became presidency, but not all of them. Not, for example, Bill Clinton or Barack Obama or others. So that's pretty extraordinary. Think about another 0. 0 religious qualifications in order to be president. Again, something that's not there. When we look at the terse text, the written Constitution, we want to focus on what's there and what's not there. No religious qualifications to be president, whereas almost every state governorship, except for Virginia, had a religious test. 2 of the 4 folks up there on Mount Rushmore, Jefferson and Lincoln, not members of not churchgoers in organized denominational sects at the time of their election. So 2 of the 4 are kind of not conventional churchgoers. 2 of the 4 presidents up there on Mount Rushmore. Think about the last presidential election. The Constitution was created by a group of largely white Protestants, mainstream Protestants. Of the 4 people running for the presidency and the vice presidency last time around, Mitt Romney is a white Protestant, but of a member of a denomination that didn't even exist at the founding, Mormonism, a kind of a new denomination. Paul Ryan and Joe Biden, both Catholics. The only mainstream Protestant, Barack Obama, non-white, father a Muslim from Africa. And so dramatic possibilities, democratic possibilities, egalitarian possibilities, simply from what's not in the Constitution, the 0, the no religious qualifications. We talked about another number that really is in the Constitution, if you look carefully, in the executive branch. In Article 2, if you look carefully, 3/5. The 3/5 clause was built into not just the apportionment of the House of Representatives, but also the structure of the Electoral College. And that's going to give, actually, southern slaveholding states a big leg up in the presidential sweepstakes, because they're going to be able to count their slaves for extra electoral votes. Remember, an anti-slavery rule wouldn't have been, 1, count slaves just like everyone else, equality. No, the question wasn't, whether slaves were going to vote. Of course they weren't going to vote. The question is how much extra clout slave states were going to get in the House of Representatives, the Electoral College, because of the existence of slavery. And 3/5 basically meant they were going to get extra clout. So the number 0, the number 3/5, the number 4. I want to remind you of one other number that we talked about, the number 1. There's 1 president at any given time. It's a very personal office, a very lonely office, a singular office. And it's always in session, 24/7. 365. Some more numbers. Now you might think, well, what about the vice presidency? Is the president really as lonely as you just said, Professor? Remember that at the founding, under Article 2, actually presidents and vice presidents don't run as teams, as tickets. Under the original Article 2 of the Constitution, the person who's vice president is simply the person who comes in second in the presidential sweepstakes. George Washington won the presidency, and John Adams came in second in the presidential contest, both in 1789 and then again in the re-election process. So the idea of a president and vice president sort of teaming up as being part of a ticket is going to emerge a little bit later on as political parties come onto the scene and are blessed by a modification of Article 2, the 12th Amendment. And we're going to talk about that in later lectures, so stay tuned. But for now, just recognize that presidents and vice presidents at the founding aren't necessarily teammates working together intimately. George Washington actually didn't rely very much on John Adams in his administration, but the very existence of the vice presidency does confirm this idea of 24/7, 365. The presidency is always in session. You always have to have a president. There are many months of the year that Congress isn't in session. Courts may go out of session, but you always have to have a president because executive power is continuous and seamless. The presidency never sleeps. And that's why the nanosecond that one president dies or resigns, the vice president, the understudy, seamlessly comes in to fill the breach. That's not true in the House of Representatives, for example. If a representative resigns or dies, we have to wait for a new election. In the Senate, if a senator dies or resigns, the governor can pick a replacement, but that's going to take some time. And the rules changed a little bit after the 17th Amendment. We'll talk about that in later lectures. And by the way, why the governor? Because in states, the governor was going to be continuously in office, and the state legislature might be in session or might not be in session. So even at the state level, this idea of executive power being continuous was kind of built into the Constitution if you read very carefully. So the importance of an executive understudy, of a number two, who can at any instant just step up and fill a breach created by a presidential death or resignation. It's an important element of the nature of executive power, American style, the seamlessness, the continuity of executive power. Now, the Constitution, Article 2, also provides, because it's so important to have a president at every moment, the Constitution also provides that if both the president and the vice president are somehow out of action, dead or disabled, have left office in a resignation, that Congress, by law, can provide for a line of succession. Now, today, the Speaker of the House is under a statute that's been passed in the 1940s, next after the vice presidency, and the president pro tem of the Senate after the Speaker. But not at all clear that that's actually what the Constitution contemplated. The Constitution says that the Congress is supposed to designate an officer to succeed a vacant presidency, vice presidency, and it's not at all clear that members of the legislature are officers in the relevant constitutional sense. At least that's what James Madison argued way back in the 1790s when Congress passed the first succession statute. That first succession statute put legislative leaders, Senate leaders and House leaders in the line of succession. And Madison said, no, no, no. Officers, by officers we meant cabinet officers, folks in effect who have been handpicked by the president to succeed him, not legislative leaders. And in fact, there's another provision of the Constitution that says that lawmakers, legislators, cannot be executive officers. In England, in a parliamentary system, you've got members of parliament who are also part of the cabinet. You've got a prime minister, the head of the executive branch, who is also a sitting member of parliament. But the Constitution, in Article 1, actually says senators and representatives can't be officers. So the minute, for example, Senator Hillary Clinton is asked to become Secretary of State Hillary Clinton, she has to leave the Senate. Senator Salazar is asked to become Cabinet Secretary Salazar. Senator Kerry is asked to become Cabinet Secretary Kerry. These folks have to leave the Senate because of a thing called the incompatibility clause in the Constitution. You can't, in America, this is a feature of American-style separation of powers, be a member of both the legislature and the executive branch. And so Madison said, now listen, how's this going to work? You can't simultaneously be Speaker of the House and President at both ends of Pennsylvania Avenue, signing bills and then deciding as Speaker of the House and then deciding whether to veto them or not as President. So it doesn't really make sense, Madison argued, for sitting lawmakers to be your caretaker presidents. And if they have to step down from the legislature in order to be president, Madison said, well then, why not actually have cabinet officers do that? Because they would be part of the administration, handpicked by the persons who had actually vacated the office. Again, this idea of executive power as very individualistic. We vote for a person as president, and if that person can't be president, why not have someone that person has handpicked, their Secretary of State, for example, carry on their mandate. In a world of political parties, Madison's ideas, I think, actually become even more powerful, because if you vote for Republicans, as George W. Bush and Dick Cheney, you shouldn't end up, if disaster strikes, with a Democrat, Nancy Pelosi. If you vote for Ronald Reagan and George H.W. Bush, you shouldn't end up with Tip O'Neill. If you vote for Barack Obama and Joe Biden, you shouldn't ever end up with John Boehner. So we're going to come back to that in later lectures. But for now, the very existence of a vice presidency confirms the unitary and continuous nature of executive power, and so does the provision for succession in the event of double death or double disability. Now, the unique personal nature of executive power is also there if we look carefully at some other words in Article 2 specifying the presidential oath of office. There's not that much in the Constitution about the presidency, and yet, word for word, the framers of the Constitution specified the presidential oath. That's a signal that they took oaths very seriously, and they wanted us to get a clear picture of what the presidency is all about. I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Okay? Now, I do solemnly swear. The Constitution begins, we do, and now here we see actually the singular, I do solemnly swear. It's a very personal office. I do solemnly swear that I will, to the best of my ability. It's a very personal office. And let's take those words and again try to look at what's there and not there, understand them in context. What's not there? I don't have to swear any religious test. Some presidents have chosen to add the words, "So help me God," after the constitutionally prescribed oath of office. Almost all the presidents in the 20th century have done so, and the 21st century. But those words aren't in the Constitution. They're a personal choice that a person can add or not add. Now, in the state constitutions, there actually were religious oaths that needed to be sworn by people before they could become governor. In England, you had to, the coronation oath required the monarch to swear to be defender of the faith. The oath had to be administered by an Anglican bishop or archbishop. Not so in the presidential oath. Doesn't specify any religious trappings. You can use a Bible if you want, but you don't have to. In England, you had to use a Bible for the monarch's coronation oath, and not just any Bible. It had to be a Protestant Bible, basically the King James Bible, not the Douay Catholic Bible. So England had all sorts of religious elements to its oath of office, but for the monarchy, but not for America's presidency, sort of a secular office. And what do you swear or affirm? Actually, you don't even have to swear. If you have a religious objection to swearing oaths, you can affirm. I do affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. You're not defender of the faith. You're not even a defender of each and every statute that Congress passes. You are a defender of the Constitution. Now, what does that mean? In England, after the Glorious Revolution of 1688-89, when kings were supposed to be limited, so that they wouldn't just rule by executive fiat, because no one had elected them. In England, monarchs pledged to follow parliamentary laws. The emergence after the Glorious Revolution of parliamentary sovereignty, and the executive branch pledged to enforce every parliamentary statute. The presidential oath doesn't quite read that way. It says, I will defend the Constitution. And maybe statutes that have been passed by the legislature might be unconstitutional. And then what's an oath-bound president to do? And I think if we read the oath carefully, the president is supposed to defend the Constitution even at the expense of a statute, because in America there's the idea that the statutes might be unconstitutional, because the Constitution comes from the people themselves, and the legislature, the Congress, is just one branch of government under the Constitution. That's not how it works in England. In England, Parliament itself is sovereign. It's the highest body. It's, in effect, the British people. And anything that it enacts is the highest law. And there's nothing quite higher than an act of Parliament, at least in the British constitutional understanding at the time of the framing. So when Parliament passes a law, that's the highest law of the land, and monarchs are supposed to unwaveringly enforce that, no matter what, even if the law, for example, violates religious rights or suppresses free speech or does other things. Monarchs are supposed to enforce, in England, the laws of Parliament. But in America, the president is supposed to defend the Constitution, and if the legislature has violated the Constitution by passing a statute that suppresses free speech or goes beyond Congress's enumerated powers or takes property without just compensation after the adoption of a Bill of Rights, or deprives people of jury trial or the like, the president is supposed to defend the Constitution and not the statute. So an important difference. And how might a president do that? One easy and obvious way from the beginning is to veto a bill that is presented to him if he thinks it's unconstitutional. So even if the House thinks the law is constitutional, and even if the Senate thinks the law is constitutional, a bill is constitutional, that doesn't end the thing. The president should simply say no and veto the bill. So measuring constitutionality in the American system is not simply and only the province of judges. It's diffused more broadly. If the House thinks it's unconstitutional, they should just vote no. If the Senate thinks it's unconstitutional, they should just vote no, and they can prevent the thing from even becoming a law. But if they both pass it, the president can veto it, and indeed, early presidents used their veto pens overwhelmingly in constitutional situations. Of the first 50 vetoes, let's say, roughly, in the pre-Civil War period, half of them were constitutionally based vetoes. Vetoes where the president sent a veto message saying, I think this bill is not merely bad policy, but is affirmatively unconstitutional. So about, say, 24 of the 50 early vetoes of the president are constitutional vetoes based on the president's constitutional oath of office to defend, preserve, protect, and defend the Constitution of the United States. By contrast, in that entire period before the Civil War, basically the Supreme Court has invalidated, well, let's say even before 1850, they've invalidated one statute using a thing called judicial review that we'll talk about in later lectures. So it's a case, 1803, Marbury versus Madison. So one judicial invalidation, 24 presidential vetoes based on constitutional objections. And many of these vetoes are vetoing laws that courts have upheld already or would uphold. We'll talk about that a little bit more in our next lecture when I actually tell you a little bit about the next picture that I want you to focus on, which is a picture of Andrew Jackson. All about, actually, this picture is going to be all about his veto power and his relationship to the Supreme Court. But in early America, in the early constitutional experience, presidents are defenders of the Constitution every bit as much as courts, arguably more so. In our next session, we're going to talk about some other presidential powers that intersect with and reinforce the veto power that we've just been talking about. And I'm going to walk you through the next picture in our series. Remember, every chapter of the book, America's Constitution, a biography, has a picture. That picture tells a story. We talked about Washington's picture, the picture of the Washington family in our previous lectures, and in the next one we're going to talk about the picture of Andrew Jackson. And if you understand that picture, you will understand the antebellum presidency. See you then. Except for Virginia had a religious test. Two of the four folks up there on Mount Rushmore, Jefferson and Lincoln, not members of, not churchgoers in organized denominational sects at the time of their election. So two of the four are kind of not conventional churchgoers. Two of the four presidents up there on Mount Rushmore. Think about the last presidential election. The Constitution was created by a group of largely white Protestants, mainstream Protestants. Of the four people running for the presidency and the vice presidency last time around, Mitt Romney is a white Protestant, but of a member of a denomination that didn't even exist at the founding, Mormonism, a kind of a new denomination. Paul Ryan and Joe Biden, both Catholics. The only mainstream Protestant, Barack Obama, non-white, father a Muslim from Africa. And so dramatic possibilities, democratic possibilities, egalitarian possibilities, simply from what's not in the Constitution, the zero, the no religious qualifications. We talked about another number that really is in the Constitution, if you look carefully, in the executive branch. In Article 2, if you look carefully, 3/5. The 3/5 clause was built into not just the apportionment of the House of Welcome back. In our previous sessions, we've been talking about Article 2 of the Constitution, the executive branch, the presidency, and we're going to continue that conversation for the next couple of sessions. We started talking about numbers that at first you might not notice, but actually contain very interesting stories. The number 4, a presidency is a 4-year term, and at the founding, that was unprecedented. No governor had a 4-year term. Only New York had a 3-year term. But today, 48 of the governors, of the 50 governors, actually have 4-year terms because their governor president, because of that invisible number, what's not there, property qualification, 0. Andrew Jackson, low-born. Ulysses S. Grant, Harry Truman, Ronald Reagan, Gerald Ford, Bill Clinton, Barack Obama. Now, some of these folks had acquired some modest fortunes by the time they became presidency, but not all of them. Not, for example, Bill Clinton or Barack Obama or others. So that's pretty extraordinary. Think about another 0. 0 religious qualifications in order to be president. Again, something that's not there. When we look at the terse text, the written Constitution, we want to focus on what's there and what's not there. No religious qualifications to be president, whereas almost every state governorships have begun to be modeled, have been, in fact, modeled on the American presidency in all sorts of ways. We talked about the number 0. 0 property qualifications in order to be president, unlike property qualifications that existed for most governorships, all the governorships really, at the time the Constitution was adopted. No governorships today. And when you think about the fact that the Constitution creates a strong presidency open to low-born persons, it's pretty remarkable when you remember that in England, the chief of the head of state is anything but low-born. He's a monarch, to the throne born. But in America, folks born in very modest circumstances have become